with the exception of ADA Travers, and I believe it is Attorney Bourgeois on the zooming in.
People are starting to trickle in now. I'll promote him when.
Okay, so he's not here yet. I'll just wait a second for him, but are there any preliminary matters that we need to address?
I think we are going to be addressing the communication with the court, with Mr. Sullivan. I think I am going to be moving some documents in as I presaged yesterday, but that should probably wait for Mr. Bourgeois.
Okay.
Although we could probably report, John, on the efforts. We made contact from here with Mr. Sullivan, and Mr. Sullivan informed Mr. McDonald that Judge Despotopoulos is on vacation until May 9th.
Okay.
So in terms of the notion of it redacting that which is claimed to be subject to the judicial deliberative privilege, we're not going to be able to do that without the judge.
Okay.
So the thought was that we would, again, leave the record open so that those redactions could be considered by you, and you could rule on it.
How about the other judge?
There was a correspondence from Mr. McDonald to Mr. Sullivan asking him to confirm that he represents the judge. Mr. Sullivan did not represent the judge in the transcript that's before us. So there is no representation to Mr. McDonald about Mr. Sullivan. I am going to move that other judge's transcript in. I'll do it right now if you want.
No, because as I said, well, has the judge been informed that this is going on? He has no legal representation?
He had legal representation at a previous point. And he subjected him, he was the subject of a sworn interview that I am going to be moving into evidence.
And this one interview was before who?
And I mentioned his name yesterday in the proceeding.
Right.
And so he has that same 4G right as Judge Despotopoulos, and efforts have been made to let him know about that.
So the sworn statement, who was that before?
Petitioner.
Okay, and you're moving to introduce that into evidence?
Yeah.
Okay, and what's your position?
I think, first of all, we need to know who represents
I
the
agree.
judge, and secondly, if there's an issue as far as 4G issue. So we don't really have a position at this point other than that.
Well, what I'm going to do, sure. Well, I should know Mr. Bourgeois is on, and he's been on for a few minutes now.
The testimony, again, taken before the commission, sworn, there was counsel present. My argument would be that the judicial privilege, the deliberative privilege doesn't apply because the judge is not involved in any of the orders that are made in this case. But in terms of redactions, there may well be claims, and I would like to suggest, and there have been, after the redactions were made, there were some fairly significant restrictions on some of the information that might be disseminated with respect to matters that came from you. And I don't think that the current exhibit, there may be something in there based upon those orders that you ordered. There may be something else that should be redacted before the record is closed.
Okay. Well, what I'm going to do, I'm going to mark the Judge D, that's A for identification, and the other judge, so it'll be B for identification. Okay. And then, hopefully, even after we rest today, that issue will remain open, subject to reaching out to both judges and giving them the opportunity to, consult with their attorney, consult with you, consult with the petitioner, and then see if you can reach an agreement. And if an agreement is reached, I would let it in. Obviously, if it's not reached, we can have a discussion at that point. Okay.
So should I also move in, may I also move in now the affidavit, transcript of Kara Colby? These two exhibits that I've just talked about, the one we're responding to, who's now at the subject of B, I think they're 5 and 6.
Okay. So
Exhibits 5 and 6.
I think, someone's gonna have to give the court reporter A for ID and B for ID, and she'll mark it and seal it, because that's still subject to the protective order. So that'll be a marked and sealed document. That's A for ID and B for ID, and just give that to the court reporter so she can do that. As for Attorney Colby's statement, do you have a position on that, Mr. McDonald?
No position on that.
Okay, so that would be whatever the exhibit is, and I would ask that you give that also to, is that a disputed exhibit?
Yes,
It was, I think it was his 5.
5 and 6, yeah, 5 is Kobe,
5 is Colby. And
6 is the other judge.
Wait, the judge, which is B for identification?
It would be B for identification.
Okay, so,
And
okay,
then,
We have that marked as B for identification.
okay, this is not B, this is the third person you mentioned, that's 5. Okay, so this would be B for identification.
okay.
Excuse me, Your Honor, we had already marked an A and B for identification that were then moved into evidence. So we do technically have.
But okay, so this would be C and D. Okay, thank you. So I apologize. So
That would be D.
so Judge,
That would be D, I apologize, I don't have Judge, did you give me Judge Despotopoulos, is it in here?
Had been,
Okay.
what, it
Could
had
you
been
tell me the
here,
number?
wasn't it?
no,
Was it?
Wasn't it right here?
Wasn't it number 1?
Please went back into the books yesterday
it
just
went
to
right
keep
into
them
the
in one
book.
place because they don't have labels on them outside the books.
So this is D. So that's the other judge, and that's D for identification. And then, and the other,
This is I apologize, Commissioner.
Yeah.
Judge Despotopoulos' AGO interview? Correct. Okay, that is 19. So this would be C,
yeah, C for identification.
thank you, sorry.
Quite all right.
And then this was the third one you
Wait.
mentioned?
Okay, hold on, give the co-reporter a second. Is that the other one? Oh.
Yep.
Okay, thank you. I noticed that there were redactions on here. That's redactions as a result of your consultation with them, with the petitioner?
they're a result of your determinations with respect to when we argued about materials coming in.
Right,
You issued orders,
okay,
and the redactions that are on, this is Ms. Colbert.
correct.
Yeah, the redactions do reflect
Okay, what,
the concerns that you had about confidentiality.
okay, well, as long as the parties are all in agreement, then I don't see a problem.
That's the first we've heard about this one being moved in, but it was previously redacted because of orders before the adjudication.
Okay.
And that would be E, Edward for identification, that last one?
No, that last one is in evidence, so whatever that
Oh, it is.
evidence is, so that's exhibit, whatever.
That's exhibit 57.
Okay, thank you.
And I'm not going to be examining anybody on it.
Oh, okay, thank you. Okay,
Should I give it to Ms. Duca?
yes, please. Okay,
Now that I've
thank you.
avoided this until this point.
Thank you very much.
Watch yourself. Yes, I just want to revisit the issue that came up yesterday afternoon at the very end when the petitioner sought to question witness DA Early on certain newspaper reports, which is Exhibit 56A through whatever. And then, although this should, as I didn't mention yesterday, although this should have been given to the respondents in a timely manner so they can examine that. It wasn't done. I recognize that, the result of which, we had a somewhat lengthy conversation yesterday. I had a short opportunity this morning to look through the documents, and yesterday I offered the parties, if you wanted to continue this till this morning, to give you an opportunity to look through the documents, but the prevailing feeling was you wanted me to make a decision. I think you knew what my decision was, that two of the attorneys, Ms. Burke and Ms. Bourgeois, objected to that, and, understandably so. I've had an opportunity to look through the documents, and I'll just note that, there were some factual, missteps that were reported, but now through this hearing, you can see that there were factual missteps, and I'm not accusing anyone in the press of making those missteps. I'll just notice that I think Mr. Bourgeois' client, ADA Travers, I think it's only mentioned once by name, and it's the most innocuous. He went into court and in open court moved to redact, which the judge allowed. And in the other statements, it just says a senior aide from the DA's office went into court and moved to redact, which was allowed by a judge. So DA Travers' name is not even mentioned, and the one time it is mentioned, it's not even in a remotely negative type of manner. And notwithstanding that, we had certainly some vociferous objections to what I was doing, and I am now left with what am I missing question. I'm going to direct it initially to Mr. Burke, and let me just explain what my problem was. I indicated early on that I was going to admit just about everything. The reason being, I'm not a judge, I'm not a hearing officer with judicial powers, and I was admitting it for the benefit of my fellow commissioners who have a right equal to mine to review all of the evidence. I also indicated then, and I reiterate now, if I were a judge, or if I had the powers of a judge, I would have allowed objections to many, if not several, of the exhibits for various reasons. I would not have allowed it into evidence. Candidly, I would have sustained more of the objections, but in fairness to my fellow commissioners, I indicated that I was going to allow it all in, which I think benefited everybody. The petitioner got a bunch of statements in, and the respondents got a bunch of statements in, just about every statement in. And then yesterday, at the very end, it's always problematic doing, when things come up at the very end of the day, it's late, we're tired, we want to move it, and, so I understand that. But at the end of the day, Mr. Bourgeois and Attorney Burke, appropriately so, I have no problem with anything that's stated in court. But you indicated that my decision was, I think you said, outrageous, which Attorney Bourgeois not only agreed with, but then intimated that I was not only being unfair, but inept because I'm not following my protective order from a month ago. And I understand that. I understand what the individual's saying. When I saw that exhibit go up yesterday, I understand precisely why the petitioner wishes to get that in. One could look at that exhibit and say, 6 weeks after the incident, it's still a red hot story. And as we all know, very often a story in the media has a shelf life of 1 to 2 days. So it's still a red hot story 6 weeks out. And we know if it's still a red hot story 6 weeks out, when it initially happened, it had to be an infernal, which is what one of your witnesses testified to. Major Hughes indicate that there was an explosion of publicity on par with the marathon bombing and the arrest of Aaron Hernandez. So by my allowing in evidence, theoretically supporting the position of the respondents who have fought for 3 weeks about talking about pretrial publicity and why we had to do what we do, and I'm admitting into evidence documents basically supporting that point of view, right? And not only does it support that point of view, it bolstered the testimony of one of the respondents' witnesses. So I'm just at a loss to say why my allowing a document that theoretically is favorable to the respondents is, by one respondent, outrageous, by another also outrageous, by a third, Mr. Riscani, who initially agreed with what I did and then stood up and said, no, now I object. The only person who did not object was Mr. Kiley. I'm not going to put words in his mouth, but perhaps he saw what I observed. So now I'm getting to that. What am I missing?
Judge, first of all, I've known you forever.
Yes.
And it's not a criticism of you.
It's not
I said
taken. It's not taken as a criticism. I'm just saying, what am I missing with by allowing this in?
When I said the word outrageous.
Yeah.
Unfortunately, you misinterpreted it.
Okay.
I said it was outrageous that they were using it as, in my opinion, as a pretext to cross-examine Joe Early with this publicity. They asked one question. That was the point of my argument, that it was not being used for a legitimate purpose. It was being used after the fact for the purpose of trying to bolster their case to try to legitimize it by what the media had reported. And the media has gotten it wrong from day one. That's what I consider to be outrageous, not your decision. And I am sorry if I personally offended you.
You did not.
Well,
You did not. I've been called long enough. I've been called worse. You have not.
you think you've been called worse, so have I. But seriously, that it really was. There's no question about the publicity. And I said to you yesterday, it's because it's re-victimizing the Bebo family again by having this barrage of unnecessary and unwarranted publicity put back into the record, so it goes into the internet again, and it's just a recapping of everything that took place that frankly there was no discussion or a debate about. You know, we didn't view it and see it as bolstering Frank Hughes' testimony.
Right.
I saw it as being punishment, further punishment of the ultimate victims in this case, and that's the Bebo family. So that's what my objection was, the petitioner who feigns their attempts to keep the publicity level down and not to bring this out, repeatedly has brought publicity to the fore and used it to try their case as opposed to just what the facts are. And what you said was important because you said the media got it wrong without saying that, but there are a lot of things they said weren't accurate. But they're trying to substitute that as a factual basis and predicate for their evidence here. And that is, in my opinion, outrageous. And to do it under the cover of darkness or to try to impeach Joe Early, they asked one question with it. It had nothing to do with Joe Early or legitimate cross-examination. It was done for the purpose of trying to prejudice this case by putting in publicity that ultimately was wrong and inaccurate.
Okay, no, once again, I appreciate your comments. All I'm saying is that the document that was put in, I see one could view it as you've indicated, but one can also view it as further demonstration of the ongoing pervasive pretrial publicity from day one, which is continuing up until the date of those articles, November 10th. So as I said, one can view it one way, one can view it the other way. Candidly, when I saw the headline, my view was, this started and it's still going 6 weeks later. So
That's because you're objective,
right.
and I'm coming at it from my vantage point
I agree.
as an advocate for my client. That's
Well, and Mr. Rusconi, what do you want to say?
I just wanted to reiterate what I reiterated yesterday before I started my cross with DA Early about the publicity. It's undeniable that there's publicity. Former Deputy Hughes said, yeah, there was a ton of publicity. That's not the issue for me at the time when I made the objection. It's when I was able to actually pull up on my laptop and read
Right.
just a couple of paragraphs. My concern was inaccurate publicity, which has a slant to it, which could be prejudicial. And that was my, that was my concern. Again, unlike Attorney Burke, I don't know you, we've never crossed paths. So,
Right.
I'm familiar with your work. I'm going to paraphrase George Patton talking to Field Marshal Bravo. I've read your book.
Right.
So,
Thank you.
and I was in no way suggesting that it was improper for you to consider that. It's just my concern was the inaccuracies. And I didn't think it was necessary. And I don't think it was just a trier effect for even accurate reporting in the media. That was just my main point.
No, I'm not being critical of anyone, we've all done 1,000 trials, if not more, and I understand what everybody's saying, so, and I am not being critical of anyone. Mr. Bourgeois, what do you have to say, sir? Yeah, you're on moods.
Right. Can you hear me all right?
Sure.
Okay. Just two things. First, I don't think it was the protective order that we were talking about being violated. It was your pre-hearing order, I think dated March 16th, where you required documents to be identified in advance and served on the other side.
I agree.
And when I was in the occasion where I was using a document, and I had to use a document on direct to Mr. Travers, there were the first arrest reports, I took the step of sending them on the Saturday before the Wednesday that he testified, because I knew the other side didn't have the documents. I didn't want there to be any unfair surprise. So I sent them on the Saturday before Easter, I think it was, documents that I planned to use on Wednesday. It is inconceivable that petitioner's counsel didn't know that they planned to use those documents for weeks in advance. This was a deliberate ambush. That's my first point, and it was a violation of your order. And if in a moment of heated anger about what I perceived as a deliberate violation of your order, I said something that offended you, I apologize. That's my first point.
Well, let me just say, you didn't say anything that offended me. As I said, I've been in court long enough. It takes a lot to offend me. What you said did not offend me.
Well, that's fine. So that was my point, that I viewed that, Judge Skinner, who I practiced in front of for many years, had a favorite phrase used. He said, "The truth doesn't need an ambush." And those words have stuck with me through my entire career, and it remains true in this situation. The truth doesn't need an ambush. They could have and should have sent those documents much earlier. And that gets me to the second point, and that is the predicate upon which Attorney Pruitt offered those documents was following a series of questions to respondent early that suggested that the pretrial publicity wasn't caused by the fact that it was a judge's daughter, wasn't caused by the salacious comments, but instead was caused by his actions. And now there's a problem with that argument, because the pretrial publicity problem in this case began as early as Judge Locke, long before there was any publicity. He recognized the risk of publicity. And a number of other witnesses said, but that's where Attorney Pruitt was going. And what she did as part of her ambush was to cherry pick certain articles that had headlines about the supposed cover-up or the supposed actions in changing the report. And what she conveniently ignored were all of the early salacious and frankly distasteful articles that came out in the early phases of the publicity in Worcester, most of which surrounded a blog called Turtle Boy, which alleged inter alia that, Judge Bebo had been in direct communication with the state police or with the district attorney. And what happened was last night, the respondents' counsel had to talk among themselves and say, what do we do? Do we go back and do we show the commission, some of this salacious and outrageous early publicity and re-traumatize the family and re-victimize the woman? And we exchanged a lot of ideas about how to deal with this. But all of it, sir, happened because it was, let's not put the fine point on it, a planned ambush. The attorneys for the petitioner wanted us to be surprised, wanted us to be unprepared, and wanted to make the point that they made. That's unfair. The orders have to apply to everybody or the orders are meaningless. I still say you should exclude those documents because they were offered in violation of your order of March 16, which said documents not served in compliance with the order would be excluded.
I understand that. All I'm asking, well, the only comment I have is that the documents that I've examined, one can easily draw the conclusion and it's helpful for the respondent for the reason I already stated. So I appreciate that, and I've indicated now 3 times that the petitioner should have handed those documents over in a timely manner. I'd like to think it wasn't malicious, perhaps just a misunderstanding of what was going on. So, but it should have been handed over to you, as you said, a month ago, and then you could have planned accordingly. By my admitting it, as I've indicated, I just don't see candidly any harm to you. But so I'm going to, I'm not going to change my decision, but I'll leave it at that. Kylie, you want to be heard?
I believe Ms. Pruitt, when she stood before you, indicated that that she was going to conduct cross-examination, that she wasn't required to produce them documents that were going to be used in cross-examination. And the reality is that I have used documents in cross-examination that that were not marked way back when. That's the truth. But the truth is also that I made efforts, sometimes flawed, to put them into the evil technology that Arthur runs over there, so that they could be called up. And so were we blindsided, whatever? I don't want to go there. I think that what would have happened in a normal course with respect to documents like that had not been marked up is they would have been used as chalks. And the way that we did it here with respect to the material, I think in this proceeding was we used some materials as chalks, and then if we wanted to put them in evidence, we moved them in evidence. That's what I think occurred.
Okay. Well, as I said, I just made some general observations. If anybody else wants to be heard, you don't have to. Okay. Okay, thank you. So, okay, having said that, and let me just underscore, no one offended me. I didn't, it's a heated battle. No one offended. I rarely, if ever, get offended in court. So, having said that, yes.
I just have 3 other administrative type, maybe not administrative, but matters before we get into closing arguments.
Sure.
First, I have the administrative notice binder for you.
Okay, thank you.
So I would like to submit that. I showed it to the petitioner this morning. So
Okay, come on.
give that to Ms. Duca.
Are you offering that as an exhibit, or you just want us to take administrative notice of it?
These are all statutes, rules, cases that council's asked you to take administrative notice of during the proceeding. So I don't think it needs to be an exhibit, but just for your convenience to have copies.
Okay, thank you. And you've seen this?
Yeah.
Thank you. Why don't we just mark that, what's that, E for identification? So are we up to E?
Yes.
B for identification, so, okay.
Okay, thank you. And then two other matters. In an effort to finish today, and to shorten our witnesses, I have an affidavit that I would like to submit into evidence from one of our witnesses, Mary Beth Adams. I gave this to petitioner yesterday. She is a mental health counselor who has had interactions with District Attorney Early, which her affidavit speaks to, about him referring defendants for services, substance abuse services.
Okay.
And so it's an affidavit as to her interactions with him on the opioid crisis.
Okay, so that evidence is generally already, I mean, this is just additional evidence
It's
coming in
additional
on that point.
evidence.
Okay, so, hold on one second, I just want to give this to the court report. Now, does the petitioner have an objection to
We
the?
would object,
Yeah.
Representative McKeon, just as you already said, District Attorney Early testified yesterday about his involvement in the opioid crisis. This affidavit is from a person who's not a recipient witness to any of the alleged allegations. This case is not about the opioid crisis. We can't cross-examine the person because they're not here. It's an affidavit, so we can't cross-examine. So for those reasons, we'd object to the petition.
No, I appreciate that. So that's exhibit, what, 56? Way up to 50,
You're up.
58.
58, okay, yes, so, Ms. Fiero, you want to just give that?
And then one last thing, I understand we had the discussion yesterday about the Margaret Rwamba affidavit, our motion filed under seal.
Correct.
I absolutely understand your position, that you're hesitant to bring anything under seal, and we were prepared as of after that conversation that we had, or not conversation, after I presented you our argument on the motion and you let us indicated your position, we were prepared not to call her and in fact not to even introduce the affidavit. However, circumstances changed yesterday and this, I believe, truly was outrageous. I respectfully disagree with my co-respondents counsel about the news articles not being disclosed in advance, that entire thing was outrageous, but this truly was outrageous. On cross-examination yesterday, the petitioner's counsel posed leading questions to our client, District Attorney Early, that petitioner knew was not true based on the affidavit that we had provided in advance. So I'll just, to explain a little bit, there were questions posed, the District Attorney Early didn't do anything for the individual who was, and this affidavit speaks to that. I provided petitioner with a draft of the affidavit before it was even signed, so the petitioner had that evidence before they posed the question. And I think that warrants reopening, submitting this under seal.
Still under seal.
Still under seal.
It's still under seal because it contains other, it's still the motion because it does contain other
Right.
information.
Can you redact the thing that's the under seal type of consideration? Can you redact that information? Because as I said, I'm just very hesitant to, do anything under seal.
Let me take, it's difficult because it will be difficult to understand some of these sentences if we redact it, but I think we can attempt to do it. I understand your position on under seal. But I will just note that there are other agencies who do allow, do have in their regulations or otherwise allow evidence to come under seal. And I know that you had expressed that you were informed that the commission, anything that you view becomes public. And I just would say that for the future, I think this is something the commission should consider.
It sounded strange to me, frankly.
Yeah, I don't
so,
think that's correct. So that's something
so-
that the commission should consider in the future, is at least outlining so that we all know the rules that we're playing by, whether that's in regulations or something else. Okay, I think I'll try to redact this and see if we can submit that.
Okay, okay, and what do you want to say here?
As a preliminary matter, I understood that the respondents were supposed to reach out to the judge's daughter because she's mentioned in that affidavit some very sensitive information. I thought the presiding officer had asked you, you had asked them to reach out to her to see if she had a position. I don't know if that occurred or not.
Okay, but you my friend, number one, I haven't seen the affidavit, and number two, so much has come out here in 3 weeks, it's hard to believe there's something in that affidavit, which I'm gonna say, oh my God, this is the first time I'm learning of this. So is that true?
That's fair.
So, you know, that's so, I just don't really, you know, it's good that you have this concern and, you know, I'm just not sure whether you should have that concern.
I would just like to point out for the record that we attempted to introduce this under seal, had I presented the argument to you on this, provided to petitioner in advance, and then petitioner did ask these questions, knowing what was in this affidavit of District Attorney Early. I think he answered the questions in a way that what is in the affidavit comes out, maybe not the specifics.
Becomes relevant, I agree with you now, based upon the questions posed to your client. I agree with you, and you should be allowed to introduce it, frankly. So what I could do, when I'm just thinking off the top of my head, I'll mark this out of F now for ID, and I'll just refer to the commission. You know, you're asking to consult, I'll give it to the commission and say, this is what the situation was, this is what I was told, and now we're all here. It's time to change the rule to make it so people know what they can and can't do. Yeah.
Excuse me, I think it would be helpful for you and I to have a moment together before we go through with that, if we could.
Okay,
Yeah,
well,
maybe we could
she's
take
my
a
legal
quick
advice.
break, because we would want to discuss too, whether.
Okay.
The one issue I just wanted to clarify again is, did they, pursuant to what you instructed, reach out to the judge's daughter to see if she wanted to give a statement as Judge Despotopoulos was given the opportunity to?
Well, we had made the decision that we weren't going to introduce this if it wasn't coming in under seal.
Okay.
So this matter of redaction, you know, there would be no point of something that was under seal. There wouldn't be the same concern. So we had made the decision that we weren't going to introduce it unless it was under seal. But there has been some communication, I believe, but not specifically on 4G.
4G imposes an obligation not on respondents. 4G imposes obligations on the commission. There have been efforts to communicate with indirectly, but there's been no direct contact by respondents with the daughter of the judge. And if I had to do it, I would withdraw the effort to put this in, frankly. It's
Not worth it.
I mean, the first witness told us why. Mr. Goldberg told us why. So that's, again, those are the facts. We have reached out indirectly. And 4G doesn't impose any obligation on us.
You've reached out to who?
Family members,
Of the Bebo family,
correct.
and they don't have a problem with this?
No, they have a problem with this. So,
We didn't get to that point because we decided not to
Okay.
submit the affidavit.
Okay, well, I'm just gonna take a short break, and then the
That's helpful.
speaker's gonna tell me again what I can't do.
correct.
So,
We're gonna try and redact in the meantime.
okay, so after this, we're ready to do closing
And I
argument.
want to do one other clarification point if I can.
Well, why don't we do that now, and then we
Okay.
can take the break, and then we can do the,
So, and again, this goes to whether something should be an exhibit or not. There were, and under the commission's rules, there were notices to admit for admissions. There were admissions made that establish facts. I don't know how the commission handles such admissions, whether you want the admissions entered as an exhibit, because they do establish facts for the case. I have a set that I can provide if they need to be done as an exhibit.
is that the set of facts?
No, so two things, says,
Okay.
administrative matters are supposed to be easy, yeah, right. So the commission's rules provide for notices for admissions. That was done in this case. We provided requests for admissions. There were facts that were admitted, there were facts that were denied. One of the facts that was denied was that there was a constitutional obligation with respect to pretrial publicity. There was then, in support of the motions for summary disposition on statements of agreed facts, I submitted that 643 pager. That did not result in stipulations for a variety of reasons, as articulated in correspondence. What is an issue is simply the admissions that were made at the very beginning of earlier on in the proceeding that establish facts in the case.
Well, you know, at the end of any trial, you can always file proposed findings of facts. I want you to do it under that, guys.
Do it however you want it. I have the document here.
Yeah, so I'm telling, yeah,
I apologize, I suggest that you and I should discuss that as well, if we could.
no, she's gonna yell at me again, so, okay.
Do you want my
I will just
document?
say that I think that
I know what
if
you're talking
if it's
about, I
permissible-
don't need it, but I know what you're talking about.
Okay,
If
so,
it's permissible, I think that the redaction solution may work for us, so,
Will?
yes.
Well, okay. Now, let me ask you, and once again, you know, I reached out, I asked Ms. Duca to reach out to my fellow commissioners to alert them that we're gonna probably do closing arguments today. So, you know, it's my understanding that I believe that a majority of the commissioners will be listening in. But so once we come back, we'll discuss a few what we've been discussing for 5 minutes, and then we can go into closing arguments.
From my perspective, subject to leaving the record open for these details that we've talked about, I think that I would anticipate resting without, I'm not calling myself if that's the question.
Okay, right. So you would rest, and then we can launch into closing arguments.
That would be what I anticipate. I don't know whether that's.
Are you ready?
Ready to go now?
Okay, and you ready, Mr. Rusconi?
I am ready.
And are you ready, Mr. Bourgeois?
Yes, sir.
Okay, and petitioner?
Subject to my motion, but we are.
Okay, I appreciate that. Okay, let's take, you know, you're gonna wanna gather 15 minutes, is that okay? And Mr. Turnberg always asks me, what time? So up at 11:15?
Well, I just
Okay.
think you're too kind.
Yeah.
And everybody has an expectation, be back here at 11:15.
Okay, 11:15, okay, thank you. I apologize for my taking a little longer than our break. I can assure you that I was working on these matters. As I understand, you want to file requests for admissions?
If they are to be admitted as an exhibit, they've already been filed with the commission.
Okay.
Part of the discovery, they do establish facts according to the rules. I do have copies to distribute if we want them.
Okay, do you want to be heard?
Only that I believe that these documents were supposed to be identified maybe March 24th of 2022, along with a host of other documents, so this is the first we're hearing of this.
I didn't hear.
This is the first we're hearing of this.
Okay, well,
Rules.
well, yeah, you know,
Rules say
he,
the answer's established.
okay, he's entitled to do, as I understand, he's entitled to do that under our rules, so that would be exhibit
59?
55 and
No, 59.
59. And Ms. Pruitt, you know, you can file something in opposition, obviously. So if you read it, there's a problem with it, just file something wrong with you.
I don't know what he's filed.
Your Honor,
I'd like to see it.
Given the, I guess, decision to allow that, and I also have a request for admissions as well, it's same exact argument, same circumstances.
Okay, just the same thing, right? Yeah. Okay, so just file that, and that would be exhibit 60 or whatever. Make sure you give a copy to the petitioner, and if the petitioner wants to file something in opposition, I encourage him to do it.
Can you schedule tomorrow?
Yeah, thank you.
Roy, I will send you one.
Okay, so,
Excuse me.
Yeah.
Did Attorney Rusconi provided a copy to you? Do you have a copy for us?
Yeah, I mean, I can give you a copy, it's your response to request for admission, so I
Do
believe.
you have a copy of what you're providing to the, I'm sorry, I should go to you, Mr. Hearing Officer. What-
Yeah,
If he has a copy of what he's providing to
yeah,
the,
you will get a copy. Just get her a copy, or you
Did I?
know, just work it out.
Or, I mean, again, petitioner sent it to me, so I'll be happy that somewhere, but I will send whatever I just gave
Okay.
today.
Thank you.
So how do we stand with this affidavit now?
I would like to move the admission of the Rwanda affidavit redacted, a redacted copy that redacts the information we were concerned about.
Okay, so that would be exhibit.
Can I just be heard away for?
Yeah, sure. I just want to clarify the numbers. That would be exhibit
61.
61. Okay.
So that's right.
Okay, thank you. Can I see that now for the, finally I get to see
The
it?
redacted version, yes. What we redacted is new information, but
Can the petitioner see as well?
of course,
Oh, you saw it.
she
We
has
haven't
the
seen a final-
unredacted
We
version.
don't have a final version.
Okay.
I have more than one copy if you want. Sure.
Petitioner would object to the admission. The affidavit is not relevant to proceedings. The judge's daughter is not a party. Her former employment at the Worcester DA's office, her mental health status, drug use and termination from employment are not an issue. Ms. Rwanda is not a recipient witness. Any fact at issue in the adjudicatory proceeding, it's not the type of evidence reasonable persons are accustomed to rely upon. Conduct of serious affairs contains multi-level hearsay. Specifically, if you look at paragraph 8, sometime thereafter, a victim witness advocate in my office told me that a victim with whom the judge's daughter was working had confided in her that Ms. Bebo called her at 3 a.m. So it's,
But it's blacked out what she told her. So that falls under the who cares, right?
that part is not redacted.
That is redacted.
The part before is not.
Right. So I guess the rest of the unredacted part of paragraph 8 is still multiple levels of hearsay.
Are we looking at two different documents?
Paragraph 8 just has the last portion of a sentence redacted.
It says sometime thereafter, a victim witness in my advocate in my office told me that a victim with whom Ally was working,
Right.
who had confided in her, that Ally
Right.
called her at 3 a.m. and told her that, and that's redacted, so.
Right, so, and no, I'm saying it's multiple levels of hearsay, so another victim witness advocate in the office told Ms. Rwanda that other victim witness advocate had spoken with a victim, and the victim told her that Ms. Bebo had said something, so we're,
Yeah, but we don't know what was said, so it's,
We'll start with calling at 3 a.m. in the morning. I mean, that's
Right.
the, and it's multi-level hearsay about something that's completely irrelevant.
okay, well, I appreciate that. Anything more you want to say?
that's it, it's all 4.5 years, this all took place July 2013, he's 4.5 years prior to the events of 2017. Affidavit contains no evidence Ms. Rwanda is a mental health professional or whether she rendered treatment to the judge's daughter, so she's unqualified to testify as to the mental state. It amounts to little more than office gossip. We
Okay.
heard from District Attorney Early, and I think he testified as to everything that's contained in the affidavit. So we'd object to its admission. It sounds like if it is gonna be admitted, it's not gonna be admitted under seal, it'll be a public document. But we would object
That's
to
right.
its
Seems
admission.
like one of your objections, it's cumulative to what DA Early
Cumulative with the
testified to.
testimony, again, we can't cross-examine an affidavit. It sounded like petitioner, I raised similar objections to
Okay, I appreciate
Mary
that.
Beth Adams, so thank you.
All fine arguments. What exhibit is this?
61? Is that right? 61?
61.
That's correct.
Okay, thank you.
Thank you.
Now, once again, it's my belief that the majority of the commissioners are listening in. And if they are listening in, if they have any questions, they can please send them to Ms. Duca, who will get them to me, which has been what we've been doing now for 3 weeks. So, is that it?
Yes, so, as I said, I'm not calling myself, subject to further redactions that might occur with respect to the exhibits, that ends my case.
Okay, very good. So, so I take it the evidence is over. You indicated yesterday you were not calling any witnesses on rebuttal. Is that-
Yeah, the petition doesn't anticipate, calling any further witnesses. It's my understanding, however, that the record remains open, at least until the briefs are filed, or closing argument, or something else, whichever occurs later, I think is under the
Sure, yeah.
regulations, so I understand the record's still open.
Okay, and I so we have to make decisions on C and D for ID. So yeah, that's no problem. So, okay, so with that said, everybody rests, as I understand. And then with that, so closing arguments, you have 15 minutes, but I'm going to be generous, so if you run over, you run over. Hopefully it won't be too far over. So, and I am looking at Mr. Kiley.
Tell him that.
Okay, I'm looking at. So, I don't care who goes first. I know Mr. Burke had kind of led off, so if you want to continue that, that's fine, so. Ms. Burke.
Judge, I just want to begin by thanking you personally for your patience and for the respect you've shown to all of the petition participants here. It's been a very difficult case for everybody, and part of that reason is because careers have been ruined, lives have been destroyed in this case. And this is really the first time that my client and I think the other respondents here have had a chance in an open forum to talk about what's happened to them. And you facilitated that. And I just wanted to say to you that if I have said something, and I know you're going to say no, but if I have said something to personally offend you or in any way cast doubt about your decisions, I apologize.
No need to apologize. You have not offended me at all.
I got to get it out anyway.
Okay, well, I appreciate that.
But in many ways, you've been the captain of what probably seems like a rudderless ship here at times. But the evidence is now in, and I am sure that the commissioners will view this case with an open mind and disregard the incredible amount of negative publicity that has surrounded this case from the outset. Before I talk about the facts, I want to apologize to the Bebo family, and on behalf of my client, and I'm sure the respondents feel the same thing. That what they have had to endure as a consequence of this case is beyond belief. And unfortunately, the onset of this hearing, as necessary as it may be, has resurrected many of the emotional issues and trauma that they've had to endure. And I just want to say that I apologize if there's something that I've said, but I have a client to defend. And I think anybody who is responsible for their clients feels the same way. But this case brings to fore a lot of different forces that were put into place. And to understand it, you have to go beyond just simply an ordinary, mundane OUI first offense arrest. And what's come out is you've had to understand not only the frailties of human life, but you've had to understand and learn about the tensions in October of 2017 and the personal animosities that existed between the command staff of the state police and the union. You know, you've had representatives, you know, the 3 or 4 officers that testified here, to a person talked about, you know, the conflict, the ongoing issues that were going on. And Colonel McKeon, think about the issues that he's dealing with on a day-to-day basis. I know this case seems like the priority of everything that's going on. And he's not my client, but he's got the breathalyzer issues. He's got the turnpike issues. He's got the ongoing issues, the day-to-day conflicts with the union. And he gets a phone call regarding an arrest of a judge's daughter. And it leads to how we got here. But if you look at, and you know from your own personal background, motive drives cases. What's going on in the persons of the participants' heads? What makes this thing go to where it is? And I suggest to you, and I know you're listening, and you're the ultimate determiner of credibility and facts and who's telling you the truth and who's just gilding the lily. But I want to suggest to you, you sat and you listened carefully. The underpinnings of the motive behind these salacious statements that are put into this arrest report come about as a result of what you've learned from my reading of that interview by the Attorney General's office. And it's at page 32. And the arresting officer is being interviewed by the Attorney General's on the case. And they ask him about his interplay with the bail commissioner. And you know, you've learned a lot about, I mean, you know it already, but you know about the issues that go into the equation for what bail is going to be set or not set. And relationships with family, commitments to a community, having a job, all of those are factors in addition to the lack of defaults in prior criminal history. And I'm going to read, if you would let me, just a segment on page 32. But at the time of the crash and the arrest, I had absolutely no idea who she or he was. So I told the bail commissioner, I'm sorry. She alerted me that, hey, this is Bebo's kid. Why didn't you tell me that? And I said, I didn't have to. I just have to tell you the criminal history, open cases, defaults. And she said, well, I'm going to give him his money back, being Judge Bebo. So she went to the front lobby and handed him back the cash that he brought in and got rid of the bail and let her go or let her out on personal recognizance or PR. Judge, that sets a stage. And you don't need a roadmap. You don't need somebody directing traffic to tell you that that's the underlying anger, issue, peak, whatever word you want to use, that drives the motive behind putting those statements in at the bottom of that report. And you got 7 paragraphs before that go into detail, explaining what the probable cause is, what the basis for the arrest was. And in those last 2 paragraphs, you've got this. And anybody with a child who sees that put into quotes and then try and has that said about their child would have the same reaction that any of us would have. And it isn't a matter of whether it's you agree, you put in everything about the report or nothing about the report, about the statements. They were put in there for a particularized reason of trying to damage or hurt an individual who was under arrest and who he perceived had gotten the benefit of having the bail returned to the judge. That's the underlying motive behind this entire case. And that's how we got here. You know, I just said that you know, we go through, you know, debates from experts about, they introduced somebody from the, you know, who had done the training. Nobody said that those belonged in there except for the trooper. And if you look at whether you agree with one side or another as to what goes into that arrest report, the reality is it then the next day is brought to the attention of a judge, a fact finder, somebody who makes decisions every single day, someone who is responsible for ensuring that every person, regardless of their race or creed, status, lack of status, money, or whatever, is given the same benefit of rights that everybody has when they get arrested and charged with a crime. And one of those is to not have negative, unnecessary, unwarranted pretrial publicity that is prejudicial, contained or brought to the attention of the public before a trial takes place. So this judge, and it isn't Rick McKeon who files a motion to impound, it isn't Joe Worley, and it isn't Jeff Travers. But the motion to impound is filed by a defense attorney who has an obligation to their client to do just that. And anybody with a modicum of brain power reads that and says, this doesn't belong here. And even if you say, oh yeah, well, my training says it does, you have an obligation as an attorney, defense attorney, to bring that to the attention of the judge and have the judge decide based upon objectivity as to whether or not that belongs in there. And that's exactly what happened here. And it should have stopped right then because it was done in open court with a transcript. The public has access to it, but they don't have to have access to the proceeding, but they should not have had access to that motion to impound. Petitioners never argued that the judge, the initial judge, Judge Locke, who heard that, should have ordered the impoundment. Never said that. Was Judge Locke giving Judge Bebo's daughter the benefit of unwarranted privilege because there's a lawful motion filed to impound an improper document? The answer is clear. He didn't. None of the judges, despite being dragged in here and subjected to, scrutiny for their conduct, none of those judges did anything inappropriate. It's done in open court. What did Judge Paul Dolly say when he spoke with, I believe, DA Early? He said, make sure that it's done in open court. You got nothing to hide here when it was going to be redacted. So think about it. You have a motion to impound that's lawfully done, and it's done because there's potential pretrial publicity. And it isn't because any of the respondents said that, a judge determined that. It then, a couple of days later, goes back before another judge, independently makes the determination, yep, those same statements that every witness here who is balanced and objective says it was inappropriate to have them in there should be removed, and agreed with that. And again, it's an open forum. It's done, there's a transcript of it. There's nothing to hide there. But there's an element, there's a malicious element that's afoot here. And that's when those who are seeking the removal of those in power in the state police determine that they're going to use this for their benefit. That's what drives the issue here. Because everybody knows that that motion to impound should have preserved the integrity of that initial police report. And it was leaked. And it was leaked for the purpose of trying to ruin his career, hurt my client, and just step back for a minute. See what they did with it? Within 3 weeks, filed a lawsuit alleging, you heard him testify, the arresting officer. Oh, it was discipline, it was punishment. Violated my constitutional rights. Sue Anderson, And you saw her on the stand. You even heard him say, yeah, she was empathetic. She was calm, she was polite. She explained what I had to do. It was an order. She had to obey the order just like I did. They filed a lawsuit. Judge O'Toole, George O'Toole, one of the finest judges it's interesting. We have another judge involved. Has on a motion to dismiss, launches it, throws it out of court without any discretion allowed whatsoever. They don't bring another lawsuit against Sue Anderson after that. They don't bring a lawsuit against Rick McKeon. They alleged a conspiracy. They alleged a conspiracy that Sue Anderson conspired with Rick McKeon to deprive him of his constitutional rights. And where's Sue Anderson? You know, and that's the 16th, the 17th, the 18th. She's on vacation. So the petitioner has this grandiose idea that, she's trying to benefit the judge. She doesn't participate in a single thing in terms of the involvement between Jeff Travers, any of the judges, the conversations that are had by anybody involving how the motion to redact is going to be done. She comes back on the 19th, comes into her desk, walking back from vacation. And she finds the impoundment order that she has never seen before. Oh, but you know, she got a text. She got a text the day after the arrest from her her second in command, said, oh yeah, judge's daughter was arrested. If she had any interest in trying to help the judge, what did she do? She did nothing. But they're going to have you suggest to you that, oh yeah, she did it. She wanted to help the judge because he was a judge. Who is Sue Anderson? Sue Anderson is one of 5 women who have managed to succeed in a male-dominated paramilitary organization and rise to the level of major. You do that because you don't know what you're doing, because you act inappropriately. It's just amazing that she finds herself here because she's given an order, an instruction by her supervisor, and you know all about the chain of command. This is a paramilitary organization based upon the Marines. We tell you to go, you go. And it doesn't have to be couched in, this is a direct order. She has had 35 years of knowing when she's told to do something, she's going to do it. So they try to then orchestrate, okay, well, Colonel McKeon or Colonel Ristine didn't say to you, oh, you got to change the DRE. You think about this. You have somebody who is aware of the impoundment order. She gets it on the 19th, reads it, and says, uh-oh, we got a problem here with this police report. Reads the police report, and she agrees, yeah, it's outrageous. Should never have been that. And you know, I don't want to say the words because I've said it too many times before. What's in that report? And again, I'll go back to, you know, having a child. You got to read that. You think about how outrageous that is to put that in there. She reads that, says she realized she got an impoundment order. And then again, they put the same information and more, including personal health issues that was done by the drug recognition expert. They put that into an open access, public access administrative journal so that anybody from the media who wants to find out something worthwhile to put into the press can go there and find out. So she has the temerity to have that removed because it obviously doesn't belong there. But that then becomes, well, you weren't told to do that. Judge, if she hadn't done that, and you caught this, you knew what I was doing. I said more than I probably should. You looked at me and said, we got it. When I said, obviously, she has to remove it or she's going to be in violation of the impoundment order.
I would just say, it's about 17 minutes you spoke, and I'll give you, some more time.
Sorry, I'm gonna get quick.
You can take some of mine.
That's shocking.
Yeah.
got her handwritten notes? Take a look at her notes, Judge. Any question about her credibility? Every single thing that she testified to on the stand, she says, and it's documented at 9:10 in the morning when the Ristine calls her. You think that she wrote this down in anticipation of 4 years having to testify here to demonstrate her credibility and accuracy?
I noticed that the words judge's daughter is not in those handwritten notes.
Well, yeah, I don't know if you think that's good or bad, but if the whole issue here is she's testified before you in the commission, honestly, and without any kind of guile whatsoever. She didn't know Judge Bebo. She couldn't care less. She didn't know the judge's daughter. It made no difference to her who the person was. As a human being, those statements didn't belong in it, regardless of what their rank, status, or privilege was. And she testified she would not have done it, or she would have done the same thing for anybody else. I started out by saying that this case has ruined lives. It's destroyed careers. Probably the most poignant of these is the Bebo family. You think about the slings and arrows. They didn't deserve this. Neither did the respondents. Their only chance for a form of redemption, and it's a limited form of redemption, is to have the commission find in their favor. They deserve that. The facts support that. They have done nothing that deserves the conclusions to the contrary. And I ask you in good conscience and good faith, as well as the commissioners, to find in their favor in this case.
Okay, thank you very much, Mr. Burke. Fine argument. Is Mr. Kiley going to go next?
I think I'm last.
You're going to go last, Mr. Rusconi? Are you going to go?
Yes, Your Honor.
Okay.
Your Honor, with your permission, I don't imagine this is going to be an issue. Before I start, I think it's appropriate if we take a moment to recognize who's not here, the person that I was asked to replace, and that's George McMahon. You should see the amount of work this man did, the stacks of files I had to get from his office, the amount of meticulous attention he paid to this case, the amount of diligence he put in. I've never met George. I now realize that we actually do run in the same professional circles. I'm from the South Shore. I had an office in Quincy. He has an office in Quincy, and everybody that I've spoken to about him, they don't have a bad word to say about him. And quite frankly, if you practice law in Quincy for long enough, it's tough to find somebody that you haven't rubbed the wrong way at some point. That being said, if nobody has a problem with it, I was just going to offer just 5 seconds of a moment of silence for Mr. McMahon. Thank you, everybody, for that.
Thank you.
Now, with respect to Respondent McKeon. I've heard a lot of talk about unwarranted privilege. Keeping these statements out of a report that were never going to be admissible and that had no basis for probable cause is not an unwarranted privilege. It's not the direction in which he wanted the department to go. It wasn't done because it was the judge's daughter. He hasn't spoken to Judge Timothy McBode in 20 years. Attorney Fierro, in her opening preface with 4 words, much ado about nothing. I have 4 more words. She's just an addict. That was this trooper's approach. Those are his own words. He confirmed that that was in his transcript when he was describing his interactions with her while she was being bailed. That is the exact opposite of what Colonel McKeon wants his troopers to think. It's the exact opposite of what DA Early wants his employees and wants the public to think. Colonel Ristine said the exact same thing. Deputy Hughes said the exact same thing. It's not the way we want to treat people. Now, obviously, she made a mistake, and she did put lives at risk when she crashed her car into that, it was a pole or a concrete barrier. Nobody's saying that's what's happening here. We're not saying that that was okay. What we're saying, and what McKeon has been saying this whole time, is you can enforce the law and still have empathy for people that are suffering from problems. This doesn't fall into that philosophy. She was prosecuted just like anybody else was. I would suggest, though, that there was no special treatment. Based on what I've heard, what we've all heard, she got treated worse. There's been a question posed several times. Have you ever done this before with respect to Attorney Travers, Attorney Early, Respondent McKeon, Respondent Anderson? Nobody has ever submitted an arrest report into a forum that would be made public like that before. That's why they've never had to do it. That's the whole reason why we're here. It was an OUI first offense report. Every jurist, clerk, and subsequent officers after that trooper testified that these quoted statements do not support probable cause for OUI drugs. So to find that it was somehow appropriate to include those, you would have to accept the opinion of the newly minted trooper over the first justice of the trial court, the regional justice of Worcester, a clerk that has been practicing since the Ford administration, a colonel, a deputy colonel, a lieutenant first assistant, the chief of the integrity unit, who is a walking encyclopedia of law. I learned more listening to him than I think in my first year of law school. And one of the highest ranking women in the history of the state police. And that's in addition to the guy that trained him who sat here and testified. He said that. There's been some suggestion that what he was doing was within the bounds of his training. There was a letter he was given from Colonel Gilpin. It said everything you did was appropriate pursuant to your training. The guy that trained him sat here and testified. He sat here and testified that it's not in his training. So I don't know where that conclusion comes from. I'm at a loss as far as that goes. There's been some submission of a report, the Burke report is what we've been calling it. A report that, mind you, I was able to ascertain through the newspaper that he was paid $30,000 to offer by the person who replaced Colonel McKeon. So I suggest that maybe it's not the most independent source based on that. I didn't see any real citations to legality, and it had the same issue that, oh, this is all appropriate. This is all done according to training. No, it wasn't. The guy that trained him sat right here and said the exact opposite. He said the phrase before the comment in question, perfectly paraphrased the comment in question. So if that's not piling on, I don't know what is. He said paraphrasing was sufficient. He paraphrased the most important parts of the case, which were operation. He paraphrased that just fine. He also said that you can't tell someone's level of intoxication by something they say. The trooper made the assertion that he thinks, not that he's trained, not that he's instructed, not the law holds, he thinks that it showed her level of intoxication. His own trainer says that's not something you're trained in. I mean, he was unaware, apparently, that there is case law that says you can't put the words tests in a case being prosecuted under OUI drugs and OUI alcohol. But he puts tests all over the report. His trainer said, I would never tell somebody to put tests in a report. And I asked him if he was familiar with the law that you have to refer to them as exercises, and he said he wasn't. He's a law enforcement officer. That's the law. I don't know what else to say about that. He wants to have us believe that he's not familiar with the bail statute. Now, he may be a newly minted trooper, but he was a Canton police officer for 6 years. That would have to suggest that through all those 6 years, all those interactions with bail commissioners, that he's somehow still unfamiliar, that ties to the community is something that you have to consider. Clerk Keenan said, oh, I always ask that. I ask that every time. This trooper has been a trooper for 1.5 years. Keenan's a bail commissioner in that area. I'm guessing they might have crossed paths once or twice. He says that, OUI first offense with the crash, that's standard. Says who? Everybody else has said the exact opposite. Judge Desopoulos said, absent aggravating circumstances, such as lengthy criminal history, personal cognizance is a presumption. You're entitled to it. The Trooper suggests that, these statements needed to be in quotes. Okay, fine. It takes him 7 paragraphs to get to the quoted statements. And the quoted statements are statements that would never be admissible in court. You heard 2 justices testify to that. He asserts that the statements are necessary for me to help the DA's office successfully prosecute a case. How can you successfully prosecute a case with statements you can't use? It doesn't make any sense. And there was some assertion in his Attorney General's transcript that, in his opinion, again, she'd been given preferential treatment in the past, with absolutely no basis to say that whatsoever. So I would join Attorney Burke's assertion that once this bail issue comes up, that does set the stage for everything. He suggested that this was a catalyst for him to go back to OUI training as some form of punishment. There were 3 classes of troopers that went to that same OUI training in New Braintree. His entire class went. You heard Deputy Hughes and Colonel Ristine saying, no, that wasn't the case. We're familiar with that. It was a result of lengthy study and other aggravating circumstances that eventually led to that training. It wasn't because of him. He wasn't punished. The law says an EES report is not punishment. An EES report, by the way, that as we stand here today, has never been ruled to be illegal. No one has ever said it was wrong, except for someone in the Burke report who said, well, maybe you should do this different next time. They testify that it's an educational tool used to get the point across without a formal written policy. It's a much more effective way to get things across. The trooper receives this notice, and he's not punished. He's educated, or he's congratulated. And as Colonel McKeon says, troopers gossip. They talk amongst each other. It spreads pretty fast. The point is received, the message is received. And the observation report, people have made a big deal about it. It's really got nothing to do with an unwarranted privilege. That trooper being issued an observation report isn't an unwarranted privilege for Ms. Barbeau. It's got nothing to do with her. If somebody has an issue with it, maybe it's a question for Colonel McKeon and going down that road of how the department should do things, how they should submit arrest reports, but that's not why we're here. So, and the trooper didn't even appeal it. Colonel McKeon did that, so everybody would be on notice that this isn't okay. He didn't go seeking out this OUI arrest report. It got dropped in his lap. That's the whole idea. It shouldn't get to him. Major Anderson testified that if she were that trooper's superior, she would have bounced it back. That's how this is supposed to work. This is what Colonel McKeon has been trying to drill in everybody's heads for months. Supervision has been poor. It's ending up in all kinds of issues. It ended up in a turnpike investigation that resulted in criminal conviction. It resulted in people trying to sell guns from an armory. Think how absurd that sounds. And by the way, a turnpike investigation, which Colonel McKeon pursued after he was borderline threatened that it would take down a whole bunch of people by his union rep. And he did it anyways. And he did it because he has a backbone. And lost in all of this is under Chapter 22C, which I've asked you to take administrative notice of. And I'll read. Charge of the administration and organization whereof. He is mandated to direct all inspections, investigations, and make necessary rules and regulations for the government, for the department, for reports to be made, and for performance of said employees. Flaherty versus Superintendent says the colonel's interpretation of the rules are entitled to substantial deference. So it's not what the Burke report says. It's what he says, because he's the boss. Now, a reasonable person with knowledge of the circumstances, Deputy Hughes, Colonel Ristine, Major Anderson, Judge Destopoulos, Judge Dodd, Clerk Keenan, are all seem to be on the same page, that this was done legally. It was done in an open forum to the public. The comments were unnecessary. I don't know how many adjectives we've used so far. Unnecessary, offensive, lewd, lascivious, salacious, outrageous, in your face. They jumped out. That's a compilation of what you've heard from everybody that's testified. If the commission, who I'm grateful that they've been paying such close attention by virtue of these questions that are being asked, if they're going to find for the petitioner, they will have to take the mistaken opinion of a trooper over the justice of the trial court, over the first regional justice of Worcester, over a clerk that I said has been practicing for 47 years. a deputy colonel, a lieutenant colonel, the first assistant to the district attorney himself, the chief of his integrity unit, and the guy that trained him, and again, one of the highest ranking women in the history of the state police. I find that difficult to reconcile. Colonel McKeon had a pretty tough job. He's trying to run a department that's under terrible scrutiny. There's a rift between him and the union. He's got, he's basically being threatened. He's got a guy calling him a scarecrow behind his back to his subordinates, saying that he's got to go. That's months before this. So as soon as that person saw an opportunity to push troopers to pursue this in this way, they did, or he did. Colonel McKeon didn't do this because it was the judge's daughter. He didn't do this for someone he hadn't talked to in 20 years. He did it because it was the right thing to do. He was asked to take the EES report out of that file by Dan Bennett, and he said no. Dan Bennett gave him some time to think about it. And he, quite honestly, I don't think he probably even had to think about it. He came back and he still said no. And he said no because he wanted to look himself in the mirror every day and not make himself sick to his stomach. He wanted to continue to uphold the direction of the department under his watch. He wanted to prosecute people that break the law without unnecessarily piling on people with issues. Because to him, they're not just drug addicts. To him, you could still hold them accountable and you could still maintain some semblance of humanity. The department is at a loss because he had to step down. He could have kept his career if he just took that observation report out, but it would go against everything that he's been preaching. And he should be commended for that, and he should not be scrutinized for that. So again, this has been publicized, more than we've first been publicized more than even the marathon bomb. And this is a case about pretrial publicity. And I'm confident the commissioners are going to be able to exclude all that pretrial publicity. This is exactly the thing we're trying to prevent, exactly the thing they were trying to prevent with the impoundment order, with the steps in the public to make sure that this young lady was held accountable, but also not mistreated. If there's a question, if she got special treatment, yeah, it was special treatment. It was especially bad treatment. She's still going through it. So I would suggest that after hearing all of this, because the commission doesn't have the luxury that the media has, where they can say whatever they want, make whatever decisions that they have in their own mind and put them out into the public forum. There's a legal standard that needs to be met. And I suggest that the legal standard hasn't been met, not even close. Now that we're done with 8 days of testimony, I'm not even sure how many witnesses, I think I lost count. We have the story. The story is here. Now the truth is here. And after all this publicity, Mr. Patrician seems to be the only one interested in the truth anymore. We're a couple blocks away from some of the outlets that broadcast this stuff, as you pointed out earlier, with some missteps. After 8 days of live testimony, I really do believe that the truth has been unveiled. And the truth is that there was no conspiracy. There was no attempt to give an unwarranted privilege to this young lady because of her father's status. Colonel McKeon did what he did because he believed it was right, because it was right. And again, he shouldn't be scrutinized for that. He should be commended. So I'm going to ask you to find for the respondent for that reason. Thank you.
Okay, thank you very much. Is Ms. Bourgeois, Ms. Bourgeois, you're up, sir.
Thank you very much and good afternoon. I don't think I'm going to use all of my time because the things that I want to talk about are really fairly simple and to some extent focused on my client, Mr. Travers. And Mr. Travers is charged with violation of 2 ethical provisions. And I want to begin by reminding the commission that the case against my client involves nothing more than 6 minutes of conversation between he and Clerk Keenan. And in this hearing, what Clerk Keenan said at the end of my cross-examination, I asked him a question. I'm going to read the question and the answer. It's on page 655 of the transcript. Sir, you know the difference, don't you, between somebody who's asking you a question, can we do something, and somebody who's advocating for a dishonest or unethical or corrupt course of conduct? You know that there's a line between those two, don't you? And he said, yes. And I said, isn't it true that at no time did you believe or think that my client, Jeff Travers, crossed that line? And he said, I did not believe that. The other person that my client dealt with in the 6 or 10 minutes that are involved was Judge Destatopoulos. Again, that was petitioner's witness, and I'm doing a cold cross-examination of witnesses I've never talked to before. And I asked Judge Destatopoulos, you quote, this is on page 896. You've never had, have you, any questions with the actions of my client, Jeffrey Travers, when he appeared in front of you, have you? Answer, whether he was doing something improper? Yes, sir. Answer, no. And in connection with this matter, you never felt that he crossed any ethical line, correct? His answer was correct. Those are the two witnesses against Jeffrey Travers. Both of them 40-year civil servants who understand where the ethical line is. Both of them came and said to you, my client did not cross the ethical line. Why is there still a case against Jeffrey Travers? Why does it survive that testimony? Now, one of the things I'm going to say now, and I'm going to go back to at the end of my talk, is the standard of proof, which is the preponderance of the evidence. I got news for petitioner, and they're going to like hearing this. Yes, you can cut and paste and select a pathway through all of the multiple statements that different witnesses gave and try to find an anchor or hook that you can put each element of a violation on and work your way to a final result through a patchwork of documents. But that is not a preponderance of evidence. And the oath that you took as commissioners is to decide this case by the preponderance of the evidence. And the problem with deciding the case against Jeffrey Travers is that you have to do that cut and paste. You have to ignore the preponderance of the evidence. You have to create a motivation for Jeffrey Travers independent of the motivation he testified to and every other witness testified to. Consider, for example, the following. There is no evidence in this case whatsoever that Judge Bebo or his daughter knew anything about what any of the respondents were doing. As far as we know, during the period of the actions of each respondent, Allie Bebo was in the hospital, getting that poison taken out of her system, and her parents were praying she lived through the day. There's no communication whatsoever with the Bebos. They don't know anything about any of this. That's an important fact because the allegation here is that people were trying to give a special privilege or a special status to the Bebos. Now, a lot of times when we would end the hearing, we would hear questions come in from the commissioners. And a lot of times, probably more times than not, the The question that would come in from you as commissioners would be to a different witness. Was this the first time you did something? Was this the first time you ever, were asked to modify a report? The first time you ever had an impounded case, that sort of thing? The first time. The suggestion being that, well, if it's the first time, maybe there's something wrong. So without being cute and being respectful, I want to ask the commissioners a question. It's a rhetorical question. I don't expect to get an answer, but I ask you to ask it to yourself. And that is this the first time that you have heard a case under section 23B2 or 23B3 with a person who supposedly received the special status didn't know anything about it, had no clue that they were being given a special status, had no communication at all with the people who were supposedly giving the special status? And I suggest to you the answer is, it is the first case. And if your point or the point is that the first time is an indicator that you're doing something wrong or you're doing something novel, then maybe we ought to hang on to that idea here and question why it is we've never had a case before under 23B2 or 23B3 where the recipient of the special status didn't know anything about it. And I suggest to you the answer is because there were not the recipients of special status. The problem with this case, from petitioner's standpoint, is the issue of the preponderance of the evidence. There's too much that they are asking you to ignore. They're asking you to ignore on the issue of Mr. Travers' involvement, the testimony of Mr. Early, Mr. Travers, Mr. Keenan, and Judge Despotopoulos. They're asking you to ignore on the issue of special privilege the fact that 3 different judges, Judge Locke at the beginning, Judge Dawley in the conversation with Judge Despotopoulos, and Judge Despotopoulos himself all decided that impoundment or redaction was appropriate because those comments were a threat to the young woman's fair trial rights. They're asking you to ignore the command of Rules of Professional Responsibility 3.6 and 3.8, which all the witnesses, Travers, Early, Hodgson, but most important, Judge Despotopoulos testified to. Judge Despotopoulos acknowledged that under those rules, the prosecutor has an affirmative duty to take steps to secure the accused's right to a fair trial. You can assume, if you want, that Travers is motivated to testify or Early's motivated to testify, but what was Judge Despotopoulos' motivation to testify falsely or with bias? Again, he was their witness. He wasn't our witness. So at the end of the day, you're left with a pathway through the evidence that the petitioner will provide you. They're going to, I'm sure in their brief, they're going to do a patchwork of, well, take this statement from this interview and another statement from that interview, and you can get to the end. But that's not weighing the preponderance of the evidence. That's just cut and paste. 2 more things I want to talk about, and then I'm just going to say thank you. There was a fact dispute on the question of whether, with Mr. Keenan, my client asked to simply file or have accepted by the clerk's office the revised document. Petitioner's theory was it was going to be swapped, or they wanted to have it traded or exchanged. You've heard everyone testify. But the only person involved in that conversation was Mr. Keenan. And 3 different times I asked him questions about that. Let's look at what he said. On page 644, the question was, he just asked you if you could accept the document, right? Answer, yes. Again on the page 646, and when you gave Jeff Travers the answer that you couldn't accept the document, did he argue with you? Answer, no. Did he push back? No. Insist you got to take it? Answer, no. And then on page 647, he asked you if you could take it. Correct? And the answer is right. So, yes, you can find way back in the earlier transcripts in response to leading questions from petitioner where the words may have been said differently by Mr. Keenan. But that's not the evidence that you heard at this hearing, and that's not the preponderance of the evidence. The last point I want to make has to do with the supposed conspiracy to swap out and eliminate and conceal the revised report. There's a subtle piece, but an undisputed piece of evidence that my client testified to that the petitioner never challenged. And that was that at the end, long before there was any publicity in this case, long before this hit the press, my client was assembling a package for the new prosecutor in Middlesex County. And the undisputed evidence in this case was that he meticulously took all 3 of the arrest reports, the original one, the revised one, and the redacted one. He put Post-it notes on those and sent them in a package that it fully explained what each of those documents were. And he sent that on to the new prosecutor. Petitioner never challenged that. Those are not the actions of somebody who's conspiring to conceal. Those are not the actions of someone who is trying to make evidence disappear. The problem with this case is there is too much evidence that the petitioner is asking you to ignore. And you can't ignore it without disregarding the obligation to decide it by the preponderance of the evidence. That's all I have to say, and I thank you for listening.
Thank you very much, Mr. Bourgeois. Mr. Kiley.
Thank you, Judge. I am going to try not to repeat what others have said. I adopt every one of the arguments that has been advanced here. I may not be able to do it with the passion that has been expressed by others, manifested by others, but I certainly have that feeling inside of me. The contention that there was an unwarranted privilege because this was a judge's daughter, founders on a fundamental fact that you have heard. No, there was no mention of the fact that there was a judge's daughter in the document that you referred to when you were talking with Mr. Moscone. You will also find that in the Attorney General's investigation in the interview of one of the witnesses who was before you, I believe it was Mr. Esteen, and I believe it was Exhibit 47. The same observation was made by the Attorney General's office, the inquisitor at that particular time. I notice that there's no mention of the judge's daughter here, and that's good. In contrast, there is a person who we've heard about today who did reference a judge, the judge's daughter, and that was the bail commissioner. And the bail commissioner said, and I'm going to paraphrase, you didn't tell me this was Bebo's daughter. I'm going to give him his money back because he's a judge. That individual is not here. That individual who gave the judge the money back is not answering to providing an unwarranted privilege to a judge. There's a reason for that came out clearly in these proceedings. It wasn't unwarranted. And if you were presented, or the commission had been presented with a question as to whether it was warranted or whether it was not, the fact of the matter is, the ties to the community matter, it was warranted. And it was warranted based upon principles of law that all of the lawyers in the room can acknowledge. In this case, as Mr. Bourgeois has asserted and laid out in detail, there is the evidence, the material that is there is not with reference to a judge's daughter. Now, with respect to the case itself, people attack the case. I refer to it as oblivion when I was told I couldn't talk about the situation. I want to suggest that the matter has gotten attention here beyond what has been called the norm because of the Attorney General's report that is before you as an exhibit. That report publicly referred the matter to the Ethics Commission. And in your records will show, and you certainly can take a notice of your own records, that you were asked, that the commission was asked to defer its investigation, not of my client, but you were asked to defer your investigation while they conducted their review of the matter. And it's been pointed out to you that the Attorney General has a role, and it comes in reviewing things at the beginning to see whether or not criminal proceeding is appropriate. That request is in the documents that were provided to us, but they're not publicly disclosed, I don't believe. At the end of the day, the Attorney General publicly referred something to you, not under oath, but publicly. So the case was laid on your doorstep. And it was laid on your doorstep at a point in time after the materials that Ms. Pruitt moved in yesterday had appeared in the newspapers. And so the inquiry had to occur, and this, as it has been discussed, is the first time that there has been an opportunity this is the first time that there has been a public review of the matters with witnesses who are alive. The point I want to emphasize more than anything else is that training, as you have heard, is not something that ends when somebody goes to an academy. The trooper, Mr. Rasconi referred to, I believe was Jamie Majarian. I may be mispronouncing the name. The slides that he had in front of him, I think, are admitted as Exhibit 17. Mr. Majarian testified that he drafted much of the document. And he told us that he looked at one of the documents and that he had drafted it decades before when he was employed in a municipality. And the idea here that has been conveyed today is that because of this slide that talks about putting the exact quotes in, that it was taught based upon slides that are decades old, and that freezes in time the way things are to be conducted, is an absurdity. The reality, again, of the evidence that you have heard is that training was at the forefront of people's consideration in the immediate preceding days and months of the preceded October 17th, the week, the situation, whatever we're talking about. It is indisputable that the evidence shows that District Attorney Early's attention to rules 3.6 and 3.8 occurred over a course of a long period of time, and that it was considered by the district attorney and the chief of the integrity unit in the week immediately preceding October 17th. That was the testimony of both District Attorney Early and the chief of the integrity unit, Mr. Hodgins. It is indisputable that the concern about what should go into narrative reports, arrest reports, in my mind, applications for a complaint, was a concern of the office for decades, articulated clearly in public presentations. Training, report writing was a concern on the one hand, and what you also heard was that when District Attorney Early spoke with Colonel McKeon in what is alleged to be some conspiracy, training, a suggestion was made that maybe training could take place, and that he offered to allow Christopher Hodgins to conduct the training. In the colonel's immediate preceding period of time, in the district attorney's immediately preceding period of time, issues about prejudice to defendants came up. 3.6, 3.8. And the issues around substance abuse disorder. I asked you to take notice of a statute that was in place in 2014, adding substance use disorder to the programs that allow diversion. I referenced also the statute that gives the district attorney authority with respect to those diversion programs. You also heard undisputed evidence from District Attorney Early and from Judge Despotopoulos that at this conspiratorial meeting where the swap out was being pushed, the District Attorney Early and Judge Despotopoulos were talking about scheduling a meeting to address a program that I would suggest is authorized under that statute that I asked you to take judicial notice of, to bring it to Worcester County. Petitioner has said to you at every opportunity This case is not about opioid addiction, stigma. This case is about favoritism to a judge's daughter, a favor that was not requested. It's undisputed that Judge Bebo suggested that his daughter be defaulted. It is undisputed that he asked nothing of any of the individuals with whom he dealt, whether it's Chief Justice Dawley or anybody else. No quarter was asked. As has just been discussed by my brother, Mr. Bourgeois, there is no way that there can be evidence of such a favor as supposedly was rendered here being given to these individuals. In fact, the evidence is that they have suffered, as my brother, Mr. Berg, has made eloquent reference to. And it is rehashed. And it is rehashed by these proceedings, and it is unfortunate. But what is not unfortunate is that the message that Mr. Early would have gone on forever if I had let him do it, would be that addiction is a major public safety issue. It kills people, thousands of them. It is a concern of the legislature. It is a concern of the Department of Public Safety. It is a concern of the community at large. And that has changed from the point in time that Trooper Nigerian was writing his slide 30 years ago. We lived through an era of a war on drugs. We lived through an era where we were dealing with aggressive police tactics, and it changed. But it didn't change necessarily in the rank and file. But it isn't the rank and file that get to determine policy. The individual that is seated to my right, who was referred to as a scarecrow by Mr. Pullman, according to the conversation that we heard from, I believe again it was Mr. Meskeen, had a backbone. Had a backbone. The scarecrow in that movie didn't have a backbone. This man had a backbone. He was asked to change, to retract an observation report, and he declined to do it because it would undermine his authority to lead the troopers, to lead the agency he was statutorily authorized to lead. An observation report looks forward. It doesn't look backward. It is an occasion in which it provides a teaching moment, I guess is a phrase that we've heard before. And it's a teaching moment that could get out to the troop. It was an appropriate order. The directive, let me strike this. The testimony that you heard also was undisputed that District Attorney Early did not advise Colonel McKeon about anything. He told him that the district attorney, told the colonel that he thought he had done the right thing. Doing the right thing is not wrong. This may be the rare case where I join a brother in saying that my client accused of something deserves a medal instead of condemnation, but it is certainly the case. A way that I often think about closings is to think about what an opening was, maybe to think about the evidence at the end of the case. I submit to you that Ms. Meredith Fierro's opening statement everything that was said to you in that opening statement was shown and proven during the course of these proceedings, starting with Exhibit 28 and the response of District Attorney Early to the notification that Ms. Bebo had been arrested. And it was TY, thank you, no big deal. No big deal, much ado about nothing. That same Exhibit 28 has another reference at the back end of it to a communication on October 23rd. The case was being referred out on that day. The only written communication that there is with respect to District Attorney Early and District Attorney Travers is that two-line statement on the 23rd. And it says, this is as the case is being referred out, contact McKeon when you can. I'm on something to that effect. With respect to the live testimony you heard from the two precipient individuals, Early, Travers, was not that there was some directive to go try and swap anything out. That is the allegation in the order to show cause. You can also look at a closing as whether you want to try and validate your position in your responsive pleadings. I also submit to you that if you look at the answer to the order to show cause, every single thing that is in that answer, including that there was advice with respect to the matters at hand about the powers of the district attorney, everything that is in that answer is validated. Another way of looking at a closing is to look at the way the case ended. Yesterday afternoon, Ms. Pruitt, in examining District Attorney Early, asked two questions that suggest to me the bankruptcy of this case that appears before you. Jeffrey Travers' father was a judge, wasn't he? Jane Sullivan's father was a judge, wasn't he? Is that the kind of question that leads to some kind of inference that the commission is to credit? I suggest that it isn't. And then the follow-up is these newspaper articles that grew from 1 to 2 to 7 as they have been admitted. And the discussion that followed that if anybody other than Mr. Patrician really wanted to follow, there was a pointed discussion about the background for those articles. November 7th, it was pointed out, was as the lawsuit that has been referenced today was filed. The predicate for the articles that was suggested came from the blog. The turmoil here, we talk about the press that is fed by somebody is not necessarily the same as the freedom of the press envisioned by the founders. There is no question in anybody's mind that where the matter emanated from, and it was discussed with you yesterday. When you read, and there is no question that you heard evidence about the threats that preceded it. when you all, and when you as the commissioners pay attention to Mr. Bennett's transcript that you admitted today, you're going to see that there was also a threat conveyed to Mr. Bennett through his assistant by Dana Pullman. You will find that in the document that is now in evidence. This case is a case that turns on facts and law. There was no unwarranted privilege afforded. What occurred in this case was something that is available to anybody. And the references to the truck driver's daughter, the plumber's daughter, whatever it is, that is the case. Everybody is entitled to be free of prejudicial, what is perceived as prejudicial pretrial publicity. It is the obligation that is imposed on the states of common law. Everybody in this room, you heard from, has that obligation. In the case of the district attorney and his first assistant, Jeffrey Travers, they had specific, special responsibilities with respect to it. Those specific responsibilities included taking reasonable steps with the individuals, with the agencies who had worked on the case to prevent prejudicial prior publicity that might cast opprobrium on the accused. Can anybody dispute that these statements cast opprobrium on the accused? These unconscionable statements? Of course not. The document that I think we exhibited, that we put in today, the rules of the court are rules of law. They're the equivalent of law. There was an obligation to follow them, not just authority, an obligation. And if a special favor wanted to be, somebody wanted to provide a special favor to the judge or his daughter, a null pros, as you have heard here, would have been a way of dealing with it. The fact that redaction became the norm, became the process, became a part of the process, is a function of a discussion that occurred between Clerk Keenan, the motion to redact that was filed, the motion to redact that was argued, I really should say, was not something dictated by the district attorney. There would be no indication that it was. I see the note.
The note says that you're 10 minutes over, so.
Right.
Okay,
Thank you.
thank you. Okay,
Why don't we take a 5-minute break?
sure. Okay, just getting around lunchtime, but obviously we're gonna get this done before lunch, if that's okay with everyone. Okay, let's take a 5-minute break and then we'll resume. What do you have to say, sir?
Thank you. Good afternoon, Presiding Officer Kantowicz. Good afternoon, everyone. John McDonald for the petitioner. I'll be presenting the closing arguments in regard to respondents McKeon and Travers this afternoon. In her opening statement, respondent Early's co-counsel claimed that this is a case of much ado about nothing. Respondent McKeon's counsel indicated that he had 4 words to summarize the case, and I'm going to take 4 words if I can too. After hearing the respondent's case, it's clear that respondents doth protest too much. This is not a case about the opioid crisis. This is not a case about management issues at the Massachusetts State Police. This is not a case about prejudicial pretrial publicity or the rules of professional conduct. This is a case about the arrest of a judge's daughter and the subsequent actions that the respondents took in relation to the arrest report, actions that violated the conflict of interest law. Everything else is an after-the-fact attempt to justify the respondents' actions. If the respondents had just left everything alone, this misdemeanor OUI case would have been resolved in a quiet afternoon by means of a plea agreement. Instead, the respondents didn't leave things alone, and here we are today. As for Respondent McKeon, the evidence establishes that in 2017, Mr. McKeon was the colonel of the Massachusetts State Police. On October 16th, 2017, Trooper Sevio arrested the judge's daughter, Allie Bebo. Trooper Sevio wrote an arrest report. The arrest report was consistent with his training and experience and reflected reasonable professional judgment. Sergeant Conant approved that arrest report, and Sergeant Conant's approval of the arrest report was an appropriate exercise of his supervisory responsibilities. The Mass State Police applied for a criminal complaint in the Worcester District Court, supported by the approved arrest report, and a clerk magistrate in the Worcester District Court found probable cause based on the application attached police report and issued issued a criminal complaint against the judge's daughter. After that criminal complaint issued, DA Early called Colonel McKeon and asked McKeon if he had heard about the arrest of the judge's daughter. Early expressed concern about the language in the arrest report, specifically language that the judge's daughter had performed sexual acts in exchange for heroin. McKeon had not heard about the judge's daughter's arrest, had not seen the arrest report, and told Early he would look into it. Now, prior to this telephone call, during his time as colonel of the Massachusetts State Police, Early had not previously contacted McKeon about an arrest report or expressed concern about statements contained in an arrest report. After the call with Early, McKeon asked Deputy Superintendent Frank Hughes if he had heard about a judge's daughter being arrested in Worcester. Deputy Superintendent Hughes hadn't heard anything and said he would look into it. There was a command staff meeting. During that meeting, McKeon told his command staff that he needs to be made aware of certain types of situations, like the arrest of a Lynn police officer, like the arrest of a judge's daughter. McKeon didn't tell his command staff to make him aware of every arrest of truck drivers, plumbers, blue-collar workers, just arrests in certain situations, special situations, involving special people who get special treatment, like the judge's daughter. McKeon and Early spoke again after the command staff meeting. Early asked McKeon what he was going to do about the arrest report. McKeon told District Attorney Early he can't do anything about the arrest report because that ship had sailed. McKeon thought the ship had sailed and was already too late to make any changes because the arrest report had already been filed with the court. And that arrest report that had been filed with the court had been already relied upon by an assistant clerk to find probable cause to issue a criminal complaint against the judge's daughter. As Mr. McKeon said, the arrest report was already in the system. District Attorney Early told McKeon that it wasn't too late to revise the arrest report. That revising the arrest report was the proper thing to do and the right thing to do, and McKeon agreed. During that call, Early told McKeon that the District Attorney's Office was filing a motion to redact. District Attorney Early didn't tell McKeon why it was necessary to remove anything from the arrest report if the DA's office was going to file a motion to redact. District Attorney Early didn't tell Mr. McKeon that the arrest report was already impounded or explain why it was necessary to remove language from an impounded arrest report. McKeon told Early that he would order Trooper Sevier through the chain of command to remove the language about performing sexual acts in exchange for heroin from the arrest report. McKeon acted because he viewed the call from Early as a complaint, and he doesn't typically get a call complaining about a report from a district attorney. Now, Mr. McKeon has known DA Early for many years. They're friends. They socialize together. Mr. McKeon used to work for Early. He knows Early as an attorney. Early is someone he respects. The Mass State Police has legal counsel available, but McKeon did not seek advice from the Mass State legal counsel to resolve his initial concerns that ship has sailed about changing the arrest report. Instead, McKeon resolved his initial concerns about changing the arrest report after his telephone call with District Attorney Early, and he relied on Early's statement that he could revise the arrest report and that changing the arrest report was the right thing to do and it was the proper thing to do. Subsequently, McKeon ordered to the Mass State Police chain of command that the arrest report be revised by removing the language. He also ordered that Trooper Sevier and Sergeant Conant receive negative observation reports. Deputy Superintendent Hughes said he would take care of it through the chain of command, and in fact, McKeon's order was carried out through the chain of command. Notably, McKeon did not order the arrest report to say revised on it, and he did not order the arrest report to say addendum on it. Despite his concerns about supervisory issues relating to arrest reports, as Colonel, McKeon never issued any guidelines, policies, or directives concerning supervision issues relating to writing arrest reports after the arrest of the judge's daughter. McKeon felt that issuing the negative observation reports to Trooper Sevier and Sergeant Conant would be adequate action for instructing rank and file troopers as to the requirements of report writing, because word gets around, troopers talk, and the message was conveyed. Interestingly, McKeon was not even involved with crafting the language that was used in the negative observation reports. And as Colonel, McKeon never directly ordered a negative observation report to be issued to a trooper for report writing prior to the negative observation report he ordered for Trooper Sevier. McKeon retired from the Massachusetts State Police less than a month after the judge's daughter was arrested. As to Respondent Travers, the evidence establishes that in 2017, Travers was the Worcester County Senior First Assistant District Attorney. On October 17, 2017, Travers received a copy of the arrest report and contacted District Attorney Early to alert him of the judge's daughter's embarrassing statements, including the language that the judge's daughter had performed sexual acts in exchange for heroin. On October 19, 2017, District Attorney Early told Travers to expect a revised arrest report from the Massachusetts State Police regarding the judge's daughter, and Travers received that revised arrest report. Travers went to the clerk's office and attempted to replace the original arrest report in the file with the revised arrest report. Clerk Keenan refused to allow Travers to do so. Travers and Keenan discussed a motion to redact only after Travers attempted to switch the revised arrest report for the original report, and Clerk Keenan refused to allow him to do so. When Travers went to see Keenan, he brought the revised arrest report with him rather than a written motion to redact. Travers eventually appeared and presented an oral motion in court. Travers's actions, coupled with Keenan's clear statements, show Travers' intent to do more than seek guidance. Keenan initially told Travers he could not do what Travers was asking him to do. Keenan would not have told Travers no if Travers was seeking guidance or was attempting to file a motion to redact with the clerk. After Keenan's refusal, Travers then sought guidance about other options. The evidence shows that Travers brought the revised arrest report with him to the clerk's office and attempted to switch the revised report with the original report in the clerk's file. Based on the evidence submitted, the petitioner has met its burden of proving its case in each element of the alleged violations by a preponderance of the evidence. Therefore, we ask the commission to find that all the respondents, but in my closing specifically respondents McKeon and Travers, violated Massachusetts General Laws, Chapter 268A, Sections 23B2, I, and 23B3, as alleged, and impose appropriate civil penalties. Thank you.
Thank you, sir. Ms. Pruitt?
Thank you. Candice Pruitt, representing the petitioner. So after 9 days of hearing, the respondents have still not come up with a coherent rationale for why the district attorney, his first assistant, the colonel of the state police, and a state police major took action on an impounded arrest report involving misdemeanor OUI drugs that was being transferred to another county. Petitioner filed an order to show cause against District Attorney Early alleging that he violated sections 23B2 and B3 by advising Colonel McKeon that he could revise the impounded arrest report and directing Senior First Assistant Travers to swap out the original arrest report for the revised one. I'll start first with District Attorney Early directing Mr. Travers. The petitioner is proven by preponderance of the evidence that Mr. Travers attempted to swap out the original arrest report for the revised one at Early's direction. It's why the state police sent the revised arrest report to ADA Travers. It's why DA Early told him to expect the revised arrest report. He only trusted this mission to his loyal first assistant. It's why Clerk Keenan went to see Judge Despotopoulos. The original arrest report was no longer in the RAM system because it had been overwritten. Now it was time to remove it from the court files. And Mr. Early's testimony yesterday was stunning. He testified under oath that he went to see Judge Despotopoulos on a scheduling matter. And you remember Judge Despotopoulos testifying that he was on the bench during the arraignment session when DA Early appeared at the back of his courtroom and got his attention. It was while he was speaking to Judge Despotopoulos that Clerk Brendan Keenan arrived saying that there was a revised arrest report. Early then said he asked, quote, a lot of questions. Early then testified that he went to his office and told ADA Travers to see Clerk Keenan and figure out what was going on with the arrest report. Here's the problem with this most recent iteration of what happened. The only way Clerk Keenan knew that there was a revised arrest report was that Travers, as the recipient of that arrest report, went to the clerk's office with the revised report to swap it out. And Clerk Keenan testified here that Mr. Travers wanted to replace the report that he had with the report Keenan had on file. Mr. Keenan said he could not do that. Before District Attorney Early went to speak with Judge Despotopoulos, he had spoken with Judge Dolly, who testified that he told DA Early that he had to file a motion and it had to be heard by a judge. Instead of doing what Judge Dolly told him to do, DA Early sent Mr. Travers to the clerk's office with the revised arrest report to swap it out, while he went to go speak with Judge Despotopoulos to advise him about the revised arrest report. It's also why when Clerk Keenan arrived regarding his concerns around Mr. Travers' request, Early said, according to Mr. Keenan, you can't do that? And then according to Judge Despotopoulos, he said, why can't we just change it out? As for his advice to Mr. Keenan, strike that. As for his advice to Colonel McKeon, Colonel McKeon testified that DA Early told him it was not too late to revise the arrest report after Colonel McKeon said that ship has sailed. Incredibly, DA Early testified under oath that Mr. McKeon was referring to supervision of his staff when he said that ship had sailed. Mr. McKeon also testified in his sworn interview before the commission that he's known the district attorney Early for years. He used to work for him. He's an attorney that he respects him, and that he was led to believe by District Attorney Early that removing the statements was the right thing to do. Colonel McKeon was not an attorney. He did not consult his own counsel. He was led by and relied on District Attorney Early. Now, we spent a little time going over District Attorney Early's cell phone records yesterday. It shows that he and Colonel McKeon communicated at least 6 times between October 2017 and October 2019. And there were 2 calls on the morning of October 19th. And it was after the second conversation at 8:17 a.m. that Mr. McKeon contacted Colonel Hughes which was at about 8:45 a.m. as Colonel Hughes testified. And McKeon contacted Hughes about making the changes to the arrest report. Now, District Attorney Early provides some rationales after the fact for the actions that he took regarding the arrest report. First, he said he relied on advice of counsel. But as we noted in his phone records yesterday, he didn't consult his counsel until after he advised Colonel McKeon about the revisions to the arrest report. As for the rules of professional conduct, 3.6 and 3.8, I ask everyone to actually read the rules. And you actually don't get to the comment section of the rules until you read the actual rules. And the common theme, particularly in 3.6, is that lawyers shall not make extrajudicial statements. So that's in subsection A. Subsection B says notwithstanding a lawyer may state. So we're still talking about statements. Subsection C, notwithstanding paragraph 8, a lawyer may make a statement. We're still talking about statements by lawyers. Subsection D, no lawyer associated in a firm with a lawyer subject to subsection A shall make a statement. Still, we're talking about statements by lawyers. That is what 3.6 concerns itself with. This case is not about statements made by lawyers or the state police. It's the statements made by an arrestee, her own statements, in quotes. 3.6 does not apply. I should also note that 3.6 says trial publicity, not pretrial publicity. I would also note, as to trial publicity, Judge Dawley testified that there would not be a trial in the judge's daughter's case because the evidence was overwhelming based on his experience. District Attorney Early yesterday also indicated that the evidence was overwhelming. The judge, the father of the woman at issue, told the DA's office first to default his daughter. He then told the court to default his daughter, and he said after she completed treatment, he would remove the default and plead her out. And this father, it's just not any, I mean, he's a judge, but he's also a drug court judge. He knew the process. He had made a decision as to how to proceed. This case was not going to trial. And again, this case was under impoundment, and this case was being transferred. There was no risk of trial publicity. Just to go back to the rules of professional conduct just for a moment. 3.8, the special responsibilities of a prosecutor. Thank you, counsel. To the extent that it relates to 3.6, which is about statements, 3.8F says that a prosecutor shall refrain from making extrajudicial comments. Again, these are statements by a lawyer. This case involves the statements of an arrestee. And finally, District Attorney Early says that his actions were related to the opioid crisis. And a lot of people's lives have been impacted by the scourge of addiction. But he's not trying to change everyone's arrest report. And none of the motions that to impound that he's submitted in the record relate to the redactions of statements of an arrestee on a misdemeanor OUI or drugs. District Attorney Early could not come up with another instance when he reached out to the colonel of the state police about another arrestee regarding anything. And when he testified under oath before the State Ethics Commission, in a sworn interview, represented by counsel, he talked about how he was affected. He said that the judges were going to be a little bit upset the way one of their daughters had been treated. And he said that he didn't know if they were going to place the blame on him or if they were going to place the blame on the state police. He was not concerned about the judge's daughter. After all, he fired her. And there is no evidence that he personally took any action with regard to the judge's daughter. It was about him. It was about keeping good relations with the judges and in those in the social circles in which he ran, which he testified to yesterday. And again, the case was impounded. It was going to another county, and there was nothing for him to do in this case, except perhaps, since it was being transferred and the case was impounded, perhaps reaching out to the family and saying, "Are you okay?" He didn't do that. The petitioner has proven by preponderance of evidence the district attorney early violated sections 23B2 and B3 by using his district attorney position to secure an unwarranted privilege for the judge and or his daughter, and we respectfully request that the commission impose a civil penalty. I'm now going to turn to Major Anderson. The petitioner filed a motion to show, order to show cause that Major Anderson violated sections 23B2 and B3 by using her official position as a police major, by identifying the revisions to the arrest report and ordering Trooper Sevier to make those revisions. Major Anderson had ordered Mr. Sevier to the barracks on his day off, told him what to remove from the report, and then directed him to transfer that report to the district attorney's office. Mr. Sevier testified that Major Anderson agreed with him that he wouldn't be ordered to revise the arrest report had it not involved the judge's daughter. In her sworn interview, Major Anderson testified that she and a member of her command staff decided which statements would be removed from the arrest report. Ms. Major Anderson testified yesterday that as a major, she had not previously ordered the removal of statements from an arrest report. Now, Colonel Carrie Gilpin, only the second woman in the history of the state police to be appointed colonel, issued a letter to Trooper Sevier stating that based on the report of an independent investigator, Trooper Sevier acted appropriately at all times, that his arrest report was consistent with his experience, training, and reflected reasonable judgment. The report referred to in that letter by Kevin Burke, a former Essex County District Attorney and former Secretary of Public Safety for the Commonwealth of Massachusetts, made a few findings. One being that once Trooper Sevier's report had been submitted to the court and used to support the issuance of a criminal complaint, it could be supplemented but not revised. The order to revise did not follow Mass State Police policy, procedure, or practice. Major Anderson failed to meet her professional responsibility by strictly adhering to the authoritative doctrine of following orders, and that Major Anderson told Trooper Sevier that he had done nothing wrong. And now, just as I alluded to, Major Anderson, part of her defense is that she was just following orders. Curiously, yesterday, Colonel McKeon testified that he didn't issue an order, but a request. But more importantly, Major Anderson was not required to follow an illegal order. Changing an arrest report based on who someone is or who someone might be related to violates the conflict of interest law. She knew why she was ordering Trooper Sevier to make the change. The reason why these high-ranking officials, state officials, took the actions that they did was because the woman was the judge's daughter. At the close that the petitioner has proven by a fair preponderance of the evidence that Major Anderson violated sections 23B2 and 23B3, and we respectfully request that the commission issue a civil penalty. Thank you.
Okay, thank you one and all. I'm informed it's just I know it's a lunchtime, but I'd like to, get you out of here in a few minutes. What's the issue we have to decide on
There's still the outstanding motion in limine, the motion to lift the Attorney General's protective order. The parties were to talk about the documents to see if anything further needed to be redacted.
I think I asked you this like a week ago, so I know everybody's been busy, so I just asked, and I'll just remind you, please review all that and just make sure something is not in there that should be redacted.
So we should just take a look at these documents, right? These are the
Yes,
documents we're
please,
gonna
as I
take.
mentioned,
Sure.
we were off the record, but it is the responsibility of the parties who are submitting the documents to ensure that it does not contain confidential information. So yes, I will leave all the exhibits here. Feel free to go through them and do what you need to do.
And the reference to the Attorney General order, I'm not clear on that.
I'm sorry, so that was the motion filed on the first day, or the judge entertained on the first day of the hearing. I'm sorry. Here it is, I apologize, it's this book.
We can deal with it later too, Ms. Duca.
Yeah, it's the petitioner's emergency motion to lift protective order governing Attorney General's office records. My memory, and please correct me if I'm wrong, is that Mr. Kiley, you felt that additional information should be removed. The judge, Commissioner Kantowicz, did not decide it, told the parties to look at it, see if you could come to an agreement. So it is still pending, and
Understood.
that's why I embraced it.
I got it, thank you.
Okay.
The next matter is, and I don't want to put you on the spot, Madam Court Reporter, but how long, when will the parties be able to get a copy of the transcript in your view?
We're required to say 2 weeks. It's probably gonna be less than that.
Okay, but we'll say 2 weeks, but okay, and you believe.
It'll be no more than 2 weeks. put it
Okay,
that
so,
way.
So assuming you folks get the transcript, say in 2 weeks, how much time would you want to file, some type of memo or brief, which you're not required to do? If you don't want to do it, you could walk out today and say, we're done. But if you want the opportunity to file a memorandum or a brief that the entire commission would see, so how much time do you need?
May I ask a question?
No,
No.
want to know what they were going to say.
Right.
You have a page limit, Judge?
We have a 20-page limit.
No.
No.
Do we have a page?
Yes.
We do have a page limit. Once again, where would I be with, what's the page limit?
It's 20.
20 pages. Okay, but like every single court, if there's a motion to enlarge, as long as you don't go too far over, I think you're safe. Okay, so
I have I'm resisting talking about this. I've been delayed my 50th anniversary trip for multiple years, and I'm going to be away over the weekend of May 23rd in that time period, if anybody cares.
happy anniversary, so
It's a little late.
we do care,
It's a
but,
little late, right?
yes, but,
Are you up to 51?
so,
I'm way past.
so, I'm just asking what day you want, whatever day you want is I'm probably just gonna say, okay.
You said you were away when, Tom?
I'm away to the end of May. I wish, if my wife is listening, I'm not sure when we're away. But it is, the anniversary date is May 23rd.
Okay, how about May 3rd?
No, May 3rd is next week.
Right, so we wouldn't have the transcripts until May 13th, correct? That's 2 weeks.
You serious, May 3rd?
No, June 3rd.
No,
Sorry,
June 3rd, I
June
think she
3rd.
meant.
June 3rd. That's June 3rd.
I don't know when I'm back.
Well, why don't we
But
do
June, in that range is, in that, from my perspective, in that range, shortly after that is fine.
So why don't we say June 10th, subject to you asking for an enlargement of time, which I'm telling you now, I'm gonna allow.
And I'm not going to.
Okay, so we'll say June 10th, I said? Okay, so June 10th to get that, to get that in, okay? So, are there any other matters? So, well, if this is a conclusion, I just want to thank everybody. I thought everybody did an excellent job. I want to thank Ms. Duke. I want to thank Mr. Shea, doing a great job. I want to thank Mr. Giannetti and Mr. Tuodi from the commission for setting all this up and going so smoothly. So thank you. Thank you to the court reporter for her work. Far from being upset, it was an honor to preside over this trial. It was, the Commonwealth was very well represented. I thought you did an excellent job across the board, and the people of the Commonwealth are well represented. For the respondents, Colonel and Major and Mr. DA and the Assistant DA, you were superbly represented, as was the Commonwealth. Your attorneys, all 5 of them, were superb, and I think you saw them in action in their presentations here. So frankly, it was an honor to preside over this. Mr. Rusconi, who had to step into this case, midstream, you really rose to the occasion. So thank you one and all. Have a great weekend, have a great anniversary, and I'll see you when I see you. So thank you.
Thank you.
Thank you, Judge.
Thank you very much. Thank you.